Yes, folks over there, welcome to this live stream with me, Martin Brian. And today I would like to talk about uh, something growing, something very common. It's already worldwide, but it faces a lot of legal battle, and that is nothing apart from copyright. Many people are venturing into the business of copyright. Many people are copyrighting their work, most especially their music. But the question is, are there no drawbacks? Well, there are drawbacks. For example, I would like to give you an example of Bob Marley. The family, after the passing of Bob Marley, the family of Bob Marley, of course, you know Bob Marley, reggae musician from Jamaica, who produced a lot of music with philosophy meanings. An attempt by the family of singer Bob Marley to obtain the copyrights to some of his best recordings, some of his best albums, were all in vain after all the attempts were thwarted by a judge in New York. A judge in New York by the name Dennis Cote ruled Universal Music Group, OUMG, owned the copyright to 5 albums. The later star recorded between 1973 and 1977 for Island Records. Now, Bob Marley family failed to obtain the copyright to their father's music, despite their father working hard to leave behind that legacy. Now, what's happening in Uganda is the likes of Eddie Kenzo are pushing for a total copyright policy that would see most of artists copyrighting their songs. The level at which copyright has grown goes up to an extent that even there are certain other NGOs which are offering copyrights for free to many artists. Now, I want to look at the disadvantages of copyright. Well, now, copyright is a form of protection that attaches to an original work of authorship. The moment the work of authorship is fixed in a tangible form, for example, a drawing, the moment it is put onto paper, or a song, the moment it is recorded onto compact disc. The disadvantages of copyright protection overwhelmingly outweigh the advantages. There are nevertheless several disadvantages to keep in mind. The first one is limited dissemination. Copyright protection prohibits individuals other than the owner from reproducing, displaying, or performing the protected material. Thus, copyright protection may prevent your work from being disseminated as broadly or as quickly as you might like. This is primarily a disadvantage for an author seeking public attention rather than financial gain. For example, an unknown musician may want to get our music out into the public in order to generate interest. However, people may be reluctant to distribute our songs through the internet and other media due to a fear of copyright infringement. There is also limited protection. Copyright offers limited protection. For example, copyright protects a particular expression of an idea, as in images, words, or sounds, but it does not protect the idea or concept itself. Thus, if you draw a picture of a new type of shower head, others will be prohibited from copying the drawing, but they can still use the basic premise to build an actual shower head. Thus, a disadvantage of copyright protection is that because people assume copyright protects more than it does, they may neglect to obtain other forms of application protection. In this example, patent protection. There is also a limited duration of copyright protection of your work. Copyright protection does not last forever. This is one thing you need to know. Copyright protection doesn't last forever. The duration depends on several factors. Generally, protection for a work created on or after January the 1st of 1978 lasts for only 70 years. After January 1978 lasts for only 70 years. Now, following the death of the author, determining the duration of protection for a work created prior to January the 1st, 1970 is more complicated and depends on a host of factors, including whether the work was published and whether the author who is formally applied for an extension. And of course, this is how Bob Marley's family failed in 1978. This presents problems for people attempting to use a particular work illegally, as they must do some research or contact the Copyright Office to determine whether the work has entered the public domain, or also risk committing copyright infringement. So at times you may commit copyright infringement on your own material, on your own music or song. That's another disadvantage of copyright. So when you enter into the game of copyright, you need to be so close to the court. You need to be so close to to have a lawyer of your own. Then another disadvantage or a demerit of copyrighting your material is the cost. The cost. In order to bring copyright infringement suit in court, because copyright deals with court, if the perpetrator or the culprit refuses to admit your claim. So you must register your work with the U.S. Copyright Authority if the U.S. is the one administering the platform, or your government authority, say UK, Kenya, Uganda, or maybe South Africa, wherever you are. Moreover, registration must be completed within 3 months after publication of the work, or prior to an infringement of the work. This one means if you go beyond 3 months of your work, it is complicated. You lose the copyright even if you go to register. If they make investigation and they find out that your original work, you have gone to copyright after 3 months, you get problem. Then also secondly, if somebody by mistake or it leaked, say for example, your music from the studio, and the person was the first to publish, you also get challenged in registering your copyright material. Yeah. So, prior infringement and then before 3 months is when you need to register. If you wish to seek statutory damages and attorney fees, then you need to follow these things. Unfortunately, registration takes time and requires a filing fee. So, copyrightable works. The first threshold a work must cross for copyright protection is originality under US law or your country's law. Mm. The first threshold is your law, the law that abides. However, originality is broadly defined. A modicum of creativity is all that is needed for a work to be original. The second, and often more difficult hurdle, is fixing the original work in a tangible medium. This means that others need to be able to perceive and refer back to it. Examples of tangible media include photographs, videos, and written works, even if there are several in digital format. Works not subject to copyright protection. A mere idea, even if it is the idea of something tangible, such as a book, is not copyrightable. A book is not copyrightable. Nor are concepts and discoveries things that are familiar or complex, such as words, phrases, or symbols, may also be excluded from copyright protection. So your book is not copyrightable. Your quotes, your words, or any other things I have mentioned before are not copyrightable. They are not categorized under works which can be copyrighted. Copyright protection attaches to the work that is fixed in the medium, not to the idea for the work. You may be creative genius who rivals Michelangelo. You may rival Michelangelo, Nicki Minaj, Bob Marley, Lucky Dube, and the rest, but until your painting has been fixed onto the ceiling, your audio has been fixed onto the ceiling, it is not protected by copyright law. So guys, it just gets more complicated. We move on to the next one. Is the therapeutic technique may be copyrightable. A therapeutic technique is not copyrightable in the form of an idea or something a therapist simply knows how to do. Once it is fixed in a tangible medium, recorded in a video or written on paper, for example, copyright protection may be available to the creator of therapeutic technique. Pet therapy programs have been copyrighted as well as dance and mind routines, which may be analogs to the therapeutic techniques that involve physical movement. Copyright registration. Copyright protection becomes available once an original work is fixed in a tangible medium. No further action is necessary. For example, original dance choreography is copyrighted after it is written down, plotted in computer software or film. Once the work is in a tangible medium, it is protected. The copyright holder may take the extra step of registering a copyright with the US Copyright Office or the copyright law of another country. But remember, platforms such as YouTube, Amazon, Facebook, Twitter, TikTok, all are controlled under the US government rule. Doing so makes it easier to prove the existence of a copyright, but affords no greater protection. However, registration enables the copyright holder to bring a lawsuit for copyright infringement. So, copyright only helps you to bring a lawsuit. The copyright basics. Copyrights protect original works of authorship that are fixed in a tangible form of expression, such as manuscripts and paintings. Works that qualify for copyright protection include literary and dramatic works, musical works, photographs, sound and video recordings, and architectural works. Copyright protection encompasses a work or original expressions, not the ideas or concepts that underlie these expressions. Ideas. The Copyright Act expressly bars copyright protection for ideas, specifically stating, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, embodied in such work. Congress of the U.S. included this language in the Copyright Act because it is, though it does not copyright to create monopolies on ideas, to eliminate monopolies on ideas. The public policy underlying copyright laws is that copyrights encourage people to create new works by providing creators a limited monopoly on the use of their works. If copyright protection extended to ideas, authors would be able to prevent others from using their ideas to create new works, which would undermine the traditional copyrights and have an adverse effect on your country, society. Expression. A copyright protects only a work's expressions of idea. Expressions include descriptions, discussions, explanations, and illustrations. For example, an author illustrator has the idea to create an illustrated alphabet book for children featuring animals for each letter. A copyright would protect the book's expression, its specific text and illustrations. The copyright would not prevent other author illustration from producing illustrated alphabet books featuring animals. Idea versus expression in copyright. For some copyrighted works, the boundary between idea and expression is blurry. Literal copying, such as a writer copying a paragraph from a source, or a merchant selling a pirated DVD of new movies, will be infringement in most cases. In contrast, or in opposite to what I've just said, using a basic idea that underlines someone else's work, such as a novel centered on police chief solving a small town murder, is not infringement. Courts typically try cases in which the nature of the copying lies somewhere between these two examples. They decide how much copying constitutes infringement on a case-by-case basis. Courts take into account various factors such as the nature and the extent of the copying and the originality of the copied material. In general, the courts give more protection to highly creative works than to fact-based works. The next thing that we need to look at is legal protections for ideas. Although copyright laws do not protect ideas, a person who has an idea he wants to protect has other options. The most effective way to protect an idea is to develop it so that it qualifies for copyright or protection. Patents protect useful, novel, and non-biased inventions. Although developing an idea does not protect the idea itself, the resulting expression or invention developed from the idea may be more valuable than the idea. A person with an idea may also protect it by requiring other parties to sign a confidential agreement before divulging the idea of them. Finally, some states, some countries, some nations' laws allow a plaintiff to file a theft of idea lawsuit alleging that the defendant stole the plain false idea. So those are all about copyright today. Thank you very much for watching this video. You can rewatch the live stream if you have not started from the beginning. Don't forget to check the official website www.deluo.online, which is the official website for the Luo Online, and then get the latest contents from Luo and outside the Luo. Don't forget to subscribe. If you subscribe, I will see you in the next video. Thank you and bye-bye.